in the industry because people need to get permission to use it. The trick then comes into the question of who owns and who controls. Generally speaking, the first owner of copyright is the person that creates it. The photographer takes the snap, the film director, the film producer, the person who writes the code. It gets wonderfully complex when you start looking at user-generated content through gaming engines. But generally the position is the author, is the first owner. This then gets varied by employment contracts. If you're employed and you're doing something that is pursuant to your employer, in other words, it's not something completely outside it, then your employer will own it. And in America they have a work-for-hire system, which we don't have here, which is basically if you're contracted to do something, then there's a presumption that it will be owned by the person who asked you to do it. In most cases then, the developer is usually the initial owner of copyright, and it's then the developers deal with the publisher that allows that license to move across, but it's the initial owner of that potential value who is the starting point in the negotiation process. The next point, once you go, well, I own this, is the question of what's the potential use and value, and you will know this better than I. It's to start thinking through all the potential uses of what you've created. Think about how can it be exploited. What I do see though in contracts and the histories of film contracts is these enormous paragraphs that go on for pages and pages, usually created by American lawyers who charge by the page, of descriptions of all the possible uses that your content could be put to, and making sure that they own it all. It's all the stuff like the game itself, the prequels and sequels and spin-offs, film and TV stuff, and merchandising. And then software licenses, we had a bit of a chat about before, things like the Unreal Engine. Has anyone else had any experience with things other than the kind of the prequel sequel things where the values have gone into other industries, things like that? Happy to talk about particular examples. Well, yeah, merchandising, but yeah, is there anything else that people have come across where the content developed in a game gets used for stuff that's very much outside the initial thoughts as to what it would be used for?
Yes. For the Blob, THQ actually ended up making a little figurine of him, of the main character. So it was used in kind of making a promotional toy sense.
Yeah, you see a lot of that. I think some of the first Star Wars movie, the characters in there were engaged in legal battles about some 20, 30 years later about their characters being used as action figures. It was, I don't know, I guess there'd probably be some Star Wars fans here. The guy who was the Red Leader when they're attacking the Death Star, he caused a particular big legal battle. You then move on to, well, if that's what can happen, how do we divide up the rights? And this all really depends on negotiating power, but the trick in my experience is to be aware of what the other side needs and aware of ideally what you want, and then try and find some middle ground if your power allows it. If you're competing with hundreds of other people who could do this job, you've got a very low bargaining position, but there are other instances where you've got a great personal relationship with them, where you're doing such excellent work that they must listen to, that you can start carving out of the usual grab bag of rights. And sorry, I was about to give you an example which I can't give you. The trick, I guess, is just to be very aware of what the potential uses are and their value, and then really often just trying it on, playing a bit of poker and seeing whether you can get away with it, because you never know how valuable it can be. I want to talk now just briefly about assignments and licenses. Because even in my industry, when I deal with other lawyers, there's a confusion about the value of one over the other. And I think the most important thing to learn is that in almost all cases, it doesn't matter whether it's an assignment you're dealing with or whether it's a license, because at the end of the day, it's all about whether or not you can use the stuff. An assignment, usually talking about copyright, is to do with ownership. Who owns what? And as I said, usually it's the developer who owns the stuff that they're creating. It's often the publisher looks to acquire through an assignment all those rights so it can own them themselves. It gives them a great sense of security in what they own. There are some accounting values in it being an asset. But even if you assign all your copyright to them, you can still take back from that stuff that you might want to use later through a license back. So you might assign to them all copyright in all the work that you do, then what you get back from them is a license to use that content for certain purposes. At the very least, you want to use it for your slide reels and things like that, which usually goes without saying. There may be other things. Because a license is just about use, and I'm sure you would have seen exclusive ones and non-exclusive ones. But many people don't realise that the exclusive licenses actually exclude you as the licensee from using it yourself. So if I was to grant an exclusive license to Mike down here, I wouldn't be able to use it myself. You sometimes see sole and exclusive, which is just a re-emphasis of the same thing. But just bear in mind, when you're giving that exclusive license, that is pretty much the same as giving complete ownership as well. So I guess the lesson is, don't get too fixated on assignments or licenses. Bury down and see what actually you can use your stuff for. And then finally, hoping we can open it up for a bit more of a chat rather than my monologue, it's just an example of the Warlords games, where retention of the intellectual property allowed the developer to keep rolling out some successful games, even though at the early stage there was a lot of pressure to assign all the copyright. So from there, we're really hoping you guys can just lay some questions into me. The more difficult, the more interesting. Free legal advice if you want. So, any questions from the floor?
Since you're off for free legal advice. Is the relationship between license and copyright, the thing I'm curious about is we tend to work a lot on other people like you, how can we sort of, in terms of ownership, what can we do to protect, well, I suppose, how can we negotiate for copyright the game we generate, even though it's not just the characters that the world designed? What would the copyright give us within that world we would then own? Maybe we would then go back to the publisher or whoever.
So, just because it's in my head now, unfortunately, the Jar Jar Binks example. So, if we're developing a game about Jar Jar Binks,
Wow, man,
please throw me another one. It's like having Roseanne Barr in my head or something. Sorry, Roseanne. I guess the question is, you start with what they give you, and then you look at what it is that you've created. And assuming you've got some negotiating power there, you'd really need to break down those two sides of the equation, what you created and what they gave you, and really negotiate for use. And really the contract, the law, can do it however you want to do it. As I say, they may say, you assign to us anything that you do, you can then claw that back through a license. Does that answer your question? Or can I have a bit more information?
Yeah, pretty much. I'm curious as to what, there's a few companies in here that are working on licensed properties. Some of them are in pre-production stage that I don't know about. And this would be sort of the ideal time to know what, when they start something that you phase, what is it they can hold on to as their own, as opposed to them going to